On Canberra Live with Marcus Paul, legal advice from Blumers Lawyers.
You can also give us a call if you're in trouble with the law, or maybe you're not in trouble and you just want some general advice. Bill Redpath from Blumers is in the studio. G'day, Bill.
G'day.
It's nice to see you.
And you.
Very good. Now, what about this teenager accused of exposing himself to a 13-year-old girl in our north? Now, he's been denied bail today, I've noticed, in the Children's Court. And in what circumstances does a court normally deny bail?
Okay, the main criteria for bail is whether you'll attend on the next occasion. And there are a number of factors that go into that. Obviously, whether you've got a history of not attending before, the seriousness of the offence, if you're likely to do jail time or whatever, you're more likely to run away. If you've got no ties with the territory, then, you've lived somewhere else, you're also kind of a flight risk, and they can set a range of conditions and whatever.
Sure.
That's the main concern, but there is provision for people to be detained where they're concerned that it will interfere with the evidence or interfere with the witnesses,
so
and that's what the magistrate seems to have done here. That's not people are not usually held indefinitely for that, but they may be held for a period, a week or 2 weeks on that basis, but then it reverts back to the kind of main concern, which is, will they attend court?
Okay, well, we don't want to talk about that case in particular, but when is a case usually heard in the Children's Court?
Okay, if the alleged offence occurs when someone is under the age of 18 years, they go to the Children's Court. It's a court that concentrates on diversion and, deals with people who are, not adults, and recognises that that's a factor in, how you deal with people, both in terms of hearing but also sentencing.
So, but those courts also are able to send juvenile offenders, if the case is quite serious, to incarceration, aren't they?
Yes, or if it's a sufficiently serious offence for that matter might be heard in the Supreme Court, but even though there are...
So essentially for the first case, if it's a person under the age of 18, it'll go to the Children's Court. If it's deemed serious enough, then it moves up to the Supreme Court.
That's right, otherwise it would be heard by the Children's Court magistrate, and they have a specialist magistrate who deals with these issues, and then if it's serious enough, it would be a committal hearing at the Children's Court and then go on. Otherwise, the whole matter would be dealt with in the Children's Court. But even if it goes to the Supreme Court, they deal with it having regard to the age of the accused.
Okay. Now, a motorbike rider has been sentenced to more than 3 years jail. Now, this happened after his passenger died in a crash on the Cotter Road in our west in March last year. So he pleaded guilty to a charge of culpable driving causing death. I thought the question this afternoon we'd ask you, what exactly is culpable driving?
All right. Well, what you have when there's a motor vehicle accident and your fault, you have civil action that people sue you for damages, or that your CTB insurers if they were injured. But there's also a series of criminal offences for what you may have done or failed to do. Culpable driving is the most serious of that hierarchy. It means that you've been so reckless and so negligent at such a level that you've disregarded the safety risk to others.
And that normally happens if somebody is either really seriously injured or it causes their death.
Yeah. Well, even within culpable driving, there are hierarchies of, the most serious is obviously culpable driving causing death or serious body injury, but you can also get charged with culpable driving just causing bodily injury. It then goes down to negligent driving causing injury and etc., to just negligent driving, and right down to, I suppose, offences where going through a traffic light, to where they just say, well, that's what you've done.
Okay.
These kind of cases, the culpable driving cases, are often very difficult in the sense that they do involve, a serious lapse on somebody's part, but they might otherwise have an unblemished record. But it's led to a serious consequence of somebody dying or getting seriously injured, but here dying. and it's balancing, what happened as a result of the serious failure that they made against an unblemished record, against, in most cases...
So the court's able to take into consideration certain circumstances.
Yeah, and they would look at the record, and often, this is a one-off problem. The person who's actually done it is full of remorse and guilt about what's happened, because it's usually someone they know. It may well be someone they know that they feel they've done. So they're very difficult cases of balancing those subjective factors of the offender with the offence, and particularly the consequence of the offence.
Well, for instance, a really awful situation would be perhaps a driver who is driving at night, has an accident, and let's say one of a member of his family is killed as a result of the accident. Then the court could take into consideration, given a good record, and given that maybe there was no alcohol involved, perhaps even no speeding involved, it was simply an accident. But
it probably wouldn't be culpable driving then, because you actually have to be so seriously reckless or negligent.
I see.
Okay, so in those circumstances, they may be charged with negligent driving,
but not
causing harm, or it may be that if it's simply an accident, say, skidding on black ice or whatever, that's led to that terrible consequence, but is probably not, a criminal offence, because you didn't do anything that was so negligent that justifies you being charged.
All right. We're talking to Bill Redpath from Blumers Lawyers today. If you have a question, give us a call, 6255 1206. It can be on any matter of law, maybe family law, criminal law, even wills, probates, anything like that. Give us a call, let us know. We have had one call come in. They didn't want to go on the radio, but they want to know, if an employee is under suspicion of illegal activity, do the police have the right to investigate the business that the person works for? If so, do police have the right to interfere with any of the employer's property? So I'll let you have a little think about that, Bill, and we'll come back and get your response to that.
On Canberra Live with Marcus Paul, legal advice from Blumers Lawyers.
Yeah, Bill Redpath from Blumers is joining me in the studio this afternoon. Just before we went to the break, we had a call in. If an employee is under suspicion of illegal activity, do police have the right to investigate the business that person works for? And if so, do the police also have the right to interfere with any of the employer's property? I'm thinking, Bill, the short answer to this is probably yes.
Well, it really depends, in the sense that is the suspected activity one that involves the business? Is the suggestion that as a result of the investigation that the business is somehow involved in it? The police would actually have to have a basis for investigating the business itself in order to investigate the business.
They'd have to go through a process like
that's right, and so they would have to say, well, okay, we believe X is part of a business enterprise that is doing this. And that this business is then involved in it. They could still take various actions in terms of the business that might interfere with the property. For example, they may get a warrant to get a phone tap on the person's business number, so that would be interfering with the business and their rights. But they could get a search warrant to search their office and whatever at the business, and that would interfere with obviously the business's rights, but that would still be investigating the person, so that they would be able to do that depending on their evidence, and they'd have to persuade a judge or magistrate that they had a reasonable suspicion or grounds for getting the warrants. But they would actually need then some specific evidence of the business being implicated in order to in something to investigate the business itself.
All right, so I hope our caller didn't want to come on the radio, which is fair enough. You can always call through for advice and remain anonymous. Let's move on to the ACT Court of Appeal. It's reduced the sentence for a man convicted of shooting a security guard during a robbery back in 2004. Now, how exactly does the Court of Appeal work?
Okay, what's happened is that Mr. Munro, who was appealing against conviction and sentence, it was a trial before the Supreme Court, a trial before Acting Justice Neild. he was unhappy with being convicted, and so that the next step and the last step in the ACT process is going to the Court of Appeal, and 3 judges hear that. The judges looked at the evidence and they were satisfied that the judge hadn't misdirected the jury in relation to various bits of evidence, and so they said, no, the conviction stands, the jury's decision was right about that.
So,
but they did get involved in the sentence.
Yes.
All right. Now, the co-offender who had pleaded guilty had got 9 years, whereas there was 12, 15 years, I think, to serve for Mr. Munro.
Right.
Now, but I guess the differences were that Mr. Munro had actually fired the gun that had injured the security guard, and obviously the co-accused had pleaded guilty and sort of, I guess, admitted the offence and saved the court's time. So the judges in the Court of Appeal said, well, no, we think that there's a good reason for that difference. However, it turned out the judge based some of his views as in relation to this based on Mr. Munro's record that didn't turn out to be accurate.
Oh, okay.
And so that there are a number of aspects of where it alleged he'd failed to turn up for bail and do a range of things that turned out to be a bit doubtful.
So what was the outcome?
And so they said, well, because the judge was wrong to give that so much weight when it really hadn't been proved, then there is an error, therefore we'll look at it, and they reduced his sentence by a couple of years, but he's still doing more time than the co-accused and whatever, but a couple of years.
Well, it's a complicated beast, is the legal system, isn't it?
It is, oh yes, and it's very difficult in terms of, well, what are the evidence about it, because obviously the co-accused gave evidence, and what weight do you give the co-accused in these circumstances when they pleaded guilty to it, and they've got an interest in helping the police and whatever to say these things. So yeah, all of those are really difficult issues, but the Court of Appeal said that the judge had made the right conclusions in respect to the evidence and left it to the jury, and the jury obviously were satisfied that he done it.
All right then, Bill. Well, listen, thanks for coming in. I appreciate that. That's about all we've got time for today. Bill Redpath from Blumers Lawyers. We'll see you again in a couple of weeks. And in the meantime, if you do have any questions that you'd like answered by the team at Blumers, give us a call, 6255 1206, or send us an email, 2cc.net.au, and click on the feedback icon. And the next time, we do it every Wednesday, the next time somebody from Blumers comes in, we'll try our best to answer that for you.